Hello everyone, this is your host Sayyid Amir Hussain. Welcome to Quotes Today by Livelaw, your one-step destination to all legal developments in the country. Let's start. Starting with an update on the petition related to the Delhi water crisis. Due to the severe heatwave conditions prevailing in North India, there has been an acute shortage of water in Delhi. The bench of Justice Prashant Kumar Mishra and Justice K.V. Vishwanathan heard the writ petition filed by the Delhi government seeking directions to the state of Haryana for immediate release of water to the crisis-hit national capital. The bench stated that despite taking all possible administrative measures to ensure optimization, rationing and targeted supply, there was an emergent situation in the capital, as the demand for water was increasing exponentially, but the supply was limited. As such, there was a need for additional water supply from neighboring states. According to the petitioner, the state of Himachal Pradesh agreed to share its surplus water with Delhi. However, cooperation from Haryana, which borders Delhi, is needed to release this water and help avert the crisis. To resolve the water crisis, the Supreme Court today asked the Upper Yamuna River Board to call for an emergent meeting of all stakeholder states on 5th of June and submit the minutes of the meeting as well as suggested steps to the court. Solicitor General Tushar Mehta submitted that the board could arrange for additional water. However, he emphasized that the Delhi government must address the water shortage of nearly 50% of the water supplied to the capital. He stated that as per the figures presented to the board, out of every 100 litres of water supplied to Delhi, only 48.65 litres reach the residents. The remaining 52.35% is lost due to leakage, tanker mafia and theft by industrial units. The parties today made a joint statement which was recorded to the effect that a meeting of the board would be held to decide what immediate action is required. The matter is next listed on June 6th. Stay tuned. The Supreme Court today refused to entertain a petition filed by the YSR Congress Party challenging the relaxation of postal ballot norms by the Election Commission of India in the state of Andhra Pradesh. The party had approached the Supreme Court against the decision of the Andhra Pradesh High Court in not interfering with the ECI's decision. This matter relates to a circular issued by the Election Commission on 30th May, which changed the rules about postal ballots. This change applied only to the state of Andhra Pradesh. The new rule stated that Form 13A, that is the form used to request a postal ballot, could be accepted with just the signature of an attesting officer, even if the officer's name and designation were not included. Today, the matter was heard by a bench of Justices Arvind Kumar and Sandeep Mehta. Senior advocate Dr. Abhishek Manu Singhvi, representing the YSR Congress Party, argued that this rule could lead to fraud because anyone could fake a signature if the form didn't require the officer's name and designation. He requested that postal ballots be counted strictly according to the existing conduct of election rules without following the ECI's May 30 circular, as the circular should not override established rules. Singhvi contended that the restriction on judicial interference in election matters does not apply when petitions support the election process. The bench comprising Justices P.K. Mishra and K.V. Vishwanathan today heard the petition aimed at conducting a by-election to fill a vacancy in the 167 Maniktala Legislative Assembly of West Bengal. This vacancy arose due to the death of Sadhan Pandey, who won the election for this constituency in 2021 state assembly elections. The by-election has been delayed because of an ongoing election petition filed by a BJP leader challenging the election of Sadhan Pandey in 2021. The Election Commission of India has submitted the schedule for holding the by-election in a sealed cover to the Supreme Court. The bench today, after perusing the schedule, showed inclination to accept it, noting that there was no need to keep the matter pending as the Election Commission was likely to proceed with the process of holding the by-election as per the schedule submitted in the court. The Council for Election Commission of India said that it submitted the schedule in a sealed cover as the public announcement of the schedule might impact the Model Code of Conduct. Accordingly, the court disposed of the pending civil appeals. Amid allegations of a leaked question paper for the NEET-UG 2024 exam held on 5th of May, a new writ petition has been filed in the Supreme Court calling for a reconduct of the exam. The writ petition seeks to direct the NTA, that is the National Testing Agency, to conduct the exam again in view of the allegations of the paper leak. The petition is expected to be listed before the Supreme Court vacation bench this week. Last month, on a similar petition, the Supreme Court had issued the notice. However, it had refused to stay the exam result, stating that the results of the exam held on a pan-India basis cannot be stayed. Stay tuned as we keep you updated. A special PMLA court in Mumbai has significantly remarked that fugitives in economic offences such as Nirav Modi, Vijay Mallya and Mehul Choksi were able to flee India because the investigating agencies failed to arrest them at a proper time. Special Judge M.G. Deshpande said so while addressing the objection raised by the Enforcement Directorate to an application. The application was filed by an accused seeking permission to travel abroad. The accused in this case, Vyomesh Shah, was never arrested by the ED. He appeared before the court in response to the summons and applied for his release, which was heavily opposed by the ED on several grounds to persuade the court to deny the application. The court has now granted permission to Shah to travel abroad during and until the conclusion of the trial. The court, after examining Section 19 and 45 of the PMLA, concluded that if ED does not arrest an individual under Section 19, the person cannot be taken into judicial custody when they appear in court in response to a summon. The court also called out ED for often failing to arrest the accused and then expecting the court to do its work by preventing the accused from travelling abroad. It stressed that it couldn't impose conditions on individuals who hadn't been arrested under Section 19 and had appeared in response to summons. The court questioned ED's failure to arrest Shah if it was apprehensive about flight risks and other objections raised in its response to Shah's application. The court rejected ED's argument that allowing the Shah's application will lead to situations like Nirav Modi, Vijay Mallya and Mehul Choksi. It noted that those individuals fled due to the failure of the investigating agencies to arrest them at the appropriate time. In contrast, Vyomesh Shah voluntarily appeared before the court and was not arrested by the ED. Therefore, his case could not be equated with those high-profile cases. Pursuant to allegations of electronic voting machine destruction at a polling booth in Andhra Pradesh, the Supreme Court today restrained Macherla MLA Pinelli Ramakrishna Reddy, who is from the YSR Congress party, from entering the concerned counting station or the vicinity of the same on 4th June 2024 when the counting will take place. The vacation bench of Justice Arvind Kumar and Justice Sandeep Mehta was dealing with two pleas filed against Reddy by a TDP polling agent. The pleas alleged that Reddy and his associates entered a polling booth in Macherla and destroyed EVMs. The petitioner expressed concern that this alleged incident, which occurred on polling day, might be repeating itself on the day of counting, that is tomorrow. During the hearing, the petitioner's counsel drew the court's attention to certain photographs stated to have been obtained from the Election Commission of India's web telecast and also produced a video. On the other hand, Reddy's counsel doubted the video produced in court, saying that it could not be said for sure as to who was there in the video and that Reddy came to be named in the second FIR that was registered 10 days later. But the court said that the allegations made in the complaint were prima facie to be true and accepted. The court has prohibited Reddy from entering the counting station of Macherla constituency on counting day. It further requested the High Court to dispose of the petition pending before it without being influenced by its earlier order granting interim protection to Reddy. Notably, the court expressed serious reservations about the High Court's grant of interim protection to Reddy, calling it a mockery of the system. The Punjab and Haryana High Court has directed the transfer of the trial in the 2015 Behbal Kalan firing case from Faridkot to Chandigarh. The case was registered in Punjab's Faridkot district in 2015, a week after two protesters were killed in alleged police firing while protesting against the alleged sacrilege of Shri Guru Granth Sahib by Dera Sacha Sauda Sirsa followers. The plea for transferring the trial was filed by the then SSP Charanjit Singh, who was arrested in the case. The counsel for the petitioner argued that on each and every date of hearing since the presentation of Challan in the court in 2019, a surcharged atmosphere is created by supporters consisting of radical organizations in the court complex at Faridkot in tractor trolleys and other modes of transport, raising slogans in support of the family of the deceased who are sponsored by vested interests trying to take political or religious mileage. He submitted that the security personnel employed in the court complex are mute spectators to the scene created by radical elements, and the newspapers as well as media have been reporting the proceedings of the case extensively after each date of hearing, and as such it has become difficult for the petitioner to appear in the court without fear. The court said that it must ensure propitious conditions which conduce to comparative tranquility at the trial, and that free and fair trial forms the basis of Article 21 of the Constitution. Accordingly, the trial has been shifted to Chandigarh. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Don't forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month. Thank you for watching.